In a recent video, I explained why slip and fall cases are so difficult to win. You may want to click the link to watch that video first. In this video, I'm going to explain how to win slip and fall cases. But to summarize the first video, slip and fall cases are notoriously difficult to win because the injured person must provide actual evidence that either the property owner or manager, 1, created the dangerous condition, or 2, actually knew of the dangerous condition before the slip and fall, or 3, should have known about the dangerous condition before the slip and fall. This high burden of proof can be difficult to overcome because there's often a lack of readily admissible evidence to satisfy the burden. It is simply not good enough to just say that there was water on the floor. The injured person must put forth actual evidence that the property owner was negligent. In this video, I will often refer to 2 different scenarios to explain how to win a slip and fall case. Scenario 1. Jamie is alone pushing a cart in a grocery store when she slips and falls as a result of a clear liquid on the floor. Jamie suffers a serious back injury. Scenario 2. Sam is with his wife pushing a cart in a grocery store when he slips and falls due to a liquid on the floor about 15 feet away from a cashier. Sam suffers brain damage from the fall. Jamie and Sam's wife hire lawyers. The lawyers immediately contact the grocery store and request that all evidence, including any possible video surveillance, be preserved. It is very important that you understand that until a lawsuit is filed, the store does not have to cooperate or share any evidence that it may have. The store may have video evidence, pictures, incident reports, and witness statements, but is not required to say what it has and is under no obligation to share any of it. Right off the bat, you can see how the property owner has an advantage. It is very rare that a store or other business will produce any evidence in the pre-litigation stage before a lawsuit is filed. The lawyers proceed and gather all the medical records and bills and present claims to the grocery store. In response, the grocery store responds that it did nothing wrong in Jamie's case and offers no money. The store also denies any negligence in Sam's case, but makes a small token offer of $5,000. Everything that I have said so far is very typical as to how a store will often handle a slip and fall claim. They typically do not share any evidence, and more often than not, they outright deny the claim or make a very lowball offer. If Jamie, Sam, or his wife are unable to really provide many details or evidence to help prove negligence, their lawyers are operating at a completely unfair advantage initially because the store has information that they do not have. This is also very common because when someone slips and is hurt, they are understandably not thinking about gathering evidence and making a lot of observations before leaving the store. This is why slip and fall cases are difficult and often require that a lawsuit is filed so that the injured person's lawyer can get the same evidence that the store has and level the playing field. Because the store denied Jamie's claim and made a lowball offer to Sam and refused to share any evidence, the lawyers were forced to file suit. Importantly, once a lawsuit is filed, the store will have to share the evidence that it has. In addition, after a lawsuit is filed, the lawyers for Jamie and Sam can request that the store produce other documents, including but not limited to policy and procedure manuals and inspection and maintenance records. The lawyers are also permitted to take the depositions of store managers and employees to seek additional evidence. A deposition is where a lawyer gets to ask questions to someone while they are under oath. The answers are recorded and can be used against a party to a lawsuit. In Jamie's case, there is no video surveillance that captured the exact area of the spill. However, there is video surveillance of both ends of the aisle where the fall occurred. The video begins 2 hours before the fall occurred. There are photos that show a clear liquid on the floor, but otherwise a clean floor. The store produced a policy that required that an employee walk the store every hour. The store also produced a log that stated that an employee conducted a store inspection 20 minutes before Jamie's fall occurred. However, the video does not show any employee entering or exiting the aisle where the slip occurred during the 2 hours prior to the fall. So how will this evidence be used in Jamie's case? Remember that Jamie must provide evidence that either the property owner, through its employees, 1, created the dangerous condition, or 2, actually knew of the dangerous condition before the slip and fall, or 3, should have known about the dangerous condition before the slip and fall. Without any evidence, a judge can dismiss the case without even a trial. Now let's apply the evidence produced to the law. There is still no evidence that the store created the spill. There is still no evidence that any employee actually knew of the spill before Jamie slipped. So far, Jamie would lose her slip and fall case. Now the third way to prove negligence requires evidence that the employees should have known about the dangerous condition before Jamie slipped. This is how experienced slip and fall lawyers often win the case. The grocery store will argue that it should not be held responsible because the floor was clean except for some clear water, which would have been hard for its employees to notice. The store will also argue that it had reasonable policies in place to prevent slips because it required its employees to check the floors every hour, and the log indicated that an employee inspected the floors 20 minutes before the fall. Uh-oh. So how does Jamie win? What is the store ignoring? An experienced slip and fall lawyer will have carefully watched all the video, even though a camera was not pointed at the area of the fall. An experienced lawyer will have noticed that there is actual video of both ends of the subject aisle and that not one single employee entered or exited either side of the subject aisle for the 2 hours leading up to the fall. The lawyer will use the video to show that the employees were not following the store's policy. Even more importantly, the lawyer will use the video to show that the store's log is not truthful, because it indicated an employee did a floor inspection 20 minutes before Jamie's fall, and that did not actually occur. At best for the store, the employee only partially inspected the store, and at worst, the employee did not bother to inspect the floor at all and simply lied in the store inspection log. How do we know that the employee who indicated that he or she walked the floors 20 minutes before the fall occurred did not go down that aisle? Because the video surveillance does not show any employee entering or exiting the subject aisle for the 2 hours before the fall. With this key evidence, Jamie's lawyer will be able to successfully negotiate a fair settlement from the grocery store. And if the store still does not want to compensate Jamie fairly, Jamie's lawyer will have strong evidence to win the case in a jury trial. Now let's turn to Sam's case, which will have a different set of facts from Jamie's case. Once the lawsuit is filed, the grocery store turns over photographs that show a dirty floor. The photos also show that the water on the floor was spread out and dirty with lots of footprints and cart marks. The store produces a policy to do floor inspections every hour, but does not maintain a written record showing the times that the floor was inspected and by which employee. There is no video surveillance. The slip occurred within 15 feet of a cashier. Like in Jamie's case, there is no evidence that the store actually spilled the water on the floor. Also, like Jamie's case, there is no evidence that an employee actually knew of the spill before Sam fell. So how will Sam's lawyer use this evidence? Sam's lawyer will argue that there is circumstantial evidence that allows a jury to infer that if the store had acted reasonably, it should have been aware of the spill before Sam's fall. How? Well, Sam's lawyer has multiple facts that can be used to make this inference or conclusion. First, the photos show a dirty floor. Also, the photos show dirty water that was spread out and had lots of footprints and cart marks running through it. An experienced slip and fall lawyer understands that this indicates that the spill had not just occurred. It takes time for the water to get dirty. A lot of people walk through that water. An experienced lawyer will argue that a jury can conclude that the water had been on the floor for long enough time for the store to discover it and clean it up. The lawyer will also argue that a policy to inspect the floor does not mean anything unless records are actually kept showing the times that it is actually inspected. And the final piece of important evidence is the fact that a cashier was working 15 feet away from the spill. The lawyer will argue that the cashier was close enough to the spill, and if the cashier was doing his or her job, should have been able to discover the spill before Sam's fall. In fact, Sam's lawyer does not need all those favorable facts. All it sometimes takes is one piece of favorable evidence that someone could use to infer that the store had sufficient time to discover the danger and remedy it before the fall. Of course, the more favorable evidence, the stronger the case. Armed with this evidence, Sam's lawyer should be able to negotiate a fair settlement. And like in Jamie's case, if the grocery store does not want to compensate Sam fairly, Sam's lawyer will have strong evidence to present to a jury. Slip and fall cases are notoriously difficult to win because the burden of proof is on the injured person to come forward with evidence showing that a property owner had sufficient awareness of a danger and time to rectify the danger before someone is hurt. As explained, often a lawyer does not have much evidence to prove a slip and fall case without filing a lawsuit. However, there are things that you can do to help your lawyer if you are involved in a slip and fall. Unfortunately, when someone slips in public, they are often understandably embarrassed. Often there is an urge to get up and leave as quickly as possible. That is the worst thing that a person can do. If you slip and fall, you should try to do the following while still on the property. 1. Ask to speak to a manager. Make sure an incident report is completed and ask for a copy, but be aware that the store will usually not give you a copy. If possible, take a picture with your phone. 2. If there are any witnesses, get their contact information immediately before they leave. 3. Use your phone to take pictures of what caused you to fall as well as the surrounding area. The more pictures, the better. The pictures may later be helpful in determining the source of the spill or show that the spill had been sitting there long enough that an employee should have known about it before the fall. 4. Take pictures of any bruises, cuts, or visible signs of injury. 5. If there is any visible substance on your clothes, take pictures. And here are important tips to follow after leaving the store. 1. After leaving the property, it is extremely important that you seek medical attention so that any injuries and pains can be documented as close as possible to the fall. 2. If there is grease, oil, or some sort of stain on your clothes, do not wash them. Put them in a bag and keep them in a safe place to preserve them as evidence. 3. Make sure you preserve the shoes that you were wearing. Do not wear them again. Put them in a bag and keep them in a safe place. Your shoes constitute evidence. The defendant may later ask you to inspect your shoes, and it can hurt your case if you got rid of what is considered important evidence. Similarly, if you continue to wear them, then the tread may be worn out by the time the defendant asks to see them. 4. And finally, contact an experienced slip, trip, and fall lawyer as soon as possible so that the lawyer can immediately begin gathering evidence, and importantly, so that a lawyer can immediately notify the property owner of the claim and its duty to preserve all evidence such as video surveillance before it is taped over. I hope this video provided you with some value. If so, I'd really appreciate if you subscribe to my channel and if you click like. Thanks for watching.